So when we talk about the frequency of meeting as per Secretarial standards 2 on general meetings, every company in each calendar year hold a general meeting called annual general meeting. Every company should hold its first annual general meeting within 9 months from the date of closing of first financial year of the company, and thereafter in each calendar year within 6 months of the close of financial year, with the interval of not more than 15 months. These provisions have been repeated from the 96 that the first AGM should be held within the closure of financial year within 9 months, and then for subsequent years from 6 months from the end of the financial year, and the consecutive meetings, the gap between the both consecutive meetings should not exceed 15 months. The aforesaid period of 6 months or interval of 15 months may be extended by a period not exceeding 3 months with the prior approval of ROC. Hold his first AGM, as it shall not be necessary for the company to hold any AGM in the calendar year of its incorporation. So, extraordinary general meeting. Items of business other than ordinary business may be considered at an AGM or by means of postal ballot if thought fit by the board. So, for the specific AGM, we see 100, and other than ordinary business is enough for here. Quorum shall be present throughout the meeting. Quorum shall be present not only at the time of commencement but also while transacting. Time of commencement and transacting. Unless the articles provide for a larger number, the quorum for a general meeting shall be. So for a public company, when there are more than 1,000, not more than 1,000, then 5 members. Personally present if the number of members are as the date of meeting is, and if from 1,000 and up to 5,000, 15 members, and from more than 5,000 is 30 members. So it is basically a logic that if there are so many members, at least 5, 15, 30 should be present. In case of private company, 2 members personally present. Where the quorum provided in the articles is higher than that provided in the Act, the quorum shall conform to such higher requirements. And here, quorum is having an upper limit of articles also. Members need to be personally present at a meeting to constitute the quorum. Proxy shall be excluded for determining the quorum. So we have seen this in 105 or proxies, that quorum will not include proxies. A duly authorized representative of a body corporate or representative of a President of India is deemed to be a member, personally present, and enjoys all the rights of a member. One person can be authorized representative of more than one body corporate. In such case, he is treated as more than one member. However, to constitute a meeting, at least 2 individuals shall be present in person. Thus, in the case of public, quorum 5 cannot form by himself but can do so if at least one more member is personally present. Members who have voted by remote voting have the right to attend, but they can't vote in the meeting as they have already voted, but they will be counted for quorum. And stipulation regarding the presence of quorum does not apply with respect to items of business transacted through postal ballot. So here is one again an important point, and other points are repeated from even the section. The stipulation regarding presence of quorum does not apply transacted to postal ballot. So now the presence of directors and auditors. The notice of EGM is also sent. EGM or EGM is also sent to directors and auditors also, and other statutory auditor. Directors. If any director is unable to attend the meeting, the chairman shall explain such absence at the meeting. The chairman of audit committee, nomination remuneration committee, stakeholder relation committee, regulation 17, regulation 18, regulation 19 of SEBI LOTR regulations has been given in detail there. or any other member of any such committee authorized by chairman of the respective committee to attend on his behalf shall attend the general meeting. So here all the chairmen of the committee can attend the meeting. Directors who attend general meetings of the company and company secretary shall be seated with the chairman, shall assist the chairman in conducting the meeting. Next is the auditors. Auditors, unless exempted by company, shall either by themselves or through their authorized representative attend the general meeting. Okay. They have the right to be heard which concern them as auditor. The authorized representative of the auditor shall also be an auditor. Secretarial auditor, same point has been repeated. Unless exempted either through his authorized representative attend at an AGM and shall have right to be heard which concern himself and secretarial auditor. The authorized representative should also be a secretarial auditor. So here next is the chairman. Chairman is where first is appointment. Shall take chair and conduct the meeting if the chairman is not present within 15 minutes. Is not present within 15 minutes. The directors will be who are present, they will be elected among themselves to be the chairman. So if there are no directors, then the members shall elect the meeting, and if there is no members, there will no unless provide the members, so the members shall elect on a show of hands. One of them shall be show of hands, and unless otherwise provided in an article's other way of appointing. A poll is demanded on the election of a chairman. It shall be taken forth in accordance with the provisions of the Act. Chairman elected on show shall continue to be chairman until some other person is elected as a chairman as a result of a poll. Such other person shall be chairman for the rest of the meeting. In case of private appointment of shall be in accordance with the articles. So, the chairman shall ensure that the meeting is duly constituted, and the chairman shall then conduct the meeting in a fair and impartial manner, shall regulate the manner in which voting is conducted, keeping in view the provisions of the Act. So, it is the general points which the chairman shall take care. Chairman shall explain the objective and implication of the resolution which they are put to vote. He shall also provide a fair opportunity to the members and clarify if they have any issues there. In case of public companies, the chairman shall not propose any resolution which is deemed to be concerned or interested. So, if the chairman is interested, he shall entrust the conduct of the proceeding in respect of such item to an non-interested director, and then he can resume the chair after that item has been done. So, next is the proxies, right to appoint. Who can appoint a proxy? So, a member entitled to attend and vote is appoint proxy, or whether that is allowed it one or more proxies to attend and vote instead of himself. Proxy need not be a member. So a proxy can act on behalf of the members not exceeding 50 and holding not aggregate 10% of the not aggregate 50 and holding not more than 10% of the total share capital of the company, carrying voting rights. So this both provisions have to be taken care together. The proxy should not be a member. Should not be a member, and he should not exceeding 50 will be allowing votes. And if and the second provision is that the person should not hold more than 10% of the paid up share capital of the company. So if 2 or 3 persons are holding 8% or 10% together, then only the proxy can be appointed for 3 persons. So, however, a member holding more than 10% of the total paid share covering may appoint a single person as proxy and shall not act as proxy for another. If a proxy is appointed for more than 50 members, he shall choose any 50 members and confirms the same. In case the proxy fails so, and the first 50 forms will be valid. In case of a private company, the points are like, you have to follow the articles. And form of proxy and instrument appointing a proxy shall be given with the notice itself, and it shall as prescribed under the Act. and it shall be signed by the appointer. And if an appointer is a body corporate, seal